So the topic before us, like I said, is topic 3 and is sources of Nigerian law. Now, what do we mean by sources of Nigerian law? The first thing that we need to agree on is the meaning of the word is source. When we're talking about source or sources, of course, you will agree with me that it's simply the origin of a thing. And the truth of the matter is that we have laws in this country, even though we do not like to keep some of the laws. It's not just about our leaders, but even we, the followers, we can be very lawless. We have laws that we've made for ourselves. We have laws that we inherited from our colonial masters. We also have laws that we borrowed from other places. And all of these laws forms the body of laws that we have as a nation. And where these laws came from is what we refer to as the source of the law. So, Nigerian law is derived from several sources, and we are going to be discussing 7 of them. The first one is Nigerian legislation. If you cannot spell anything, please ask your neighbor. Nigerian legislation. Number 2 is the received English law. The received, to receive something. The received English law. Number 3 is case law. Case law as in C-A-S-E. The 4th source of Nigerian law that we're going to examine is customary law. The 5th is Islamic law. The 7th that we are going to deal with the what? Is international law. International law. And the last but not the least is opinion of jurists and legal writers. Opinion of jurists and legal writers. When you don't know a particular word and you want me to spell it, don't just behave as if you did not hear. Behave as if you don't know the spelling, then I can spell it. What? Opinion. So those are the 7. I will recap again so that we can all get these sources. Number 1 is Nigerian legislation, followed by the received English law. The received English law. The 3rd is case law. The 4th is customary law, followed by Islamic law, international law, and the last is opinion of jurists. Jurist is spelled J-U-R-I-S-T, and legal writers. So, by way of introduction, the sources of law means the fountain of the authority of a body of law. It simply means the granting of the authorities of a body of law. We can also say that the sources of law will mean the fountain of authority of rule of law. So, when we now focus on sources of Nigerian law, we simply mean the origin of the whole body of law of Nigerian legal system. That's simply what we are talking about. Other nations of the world also have their own various legal systems. Just the way we have our own distance system, they also have theirs, and they also have different sources from where they got their own laws from. So, but as far as the Nigerian legal system is concerned, the sources of our laws are the origin of the whole body of laws that we have in our legal system. So, if you want to put it in your own language, it is where we got our laws from. And that's what we mean simply by sources of Nigerian law. Now, I've said it in this class before, and I will repeat it again, that by virtue of our relationship with our colonial masters, we borrow a whole lot of their laws into our system. And that has influenced greatly our legal system. So when you dig deep into the body of laws that we have as a nation, the laws of those that colonize us are large in number. The same thing applies to other African countries that were also colonized by, different people also. They also borrowed massively from the laws of those that colonized them. So, I'd like to say that by virtue of our history with the British, we took English law as part of the sources of our law as a people. So, therefore, it's difficult for us to talk about the sources of Nigerian law without referring to the English laws. We borrowed them in good number. So, having said that, we have listed the various sources to include Nigerian legislation, to include customary law, to include case law, to include international law, to include opinion of jurists and legal writers. So all of these sources forms what we now refer to as our own law. So we're going to take these sources one after the other in order for us to have a good grasp of what we are talking about this afternoon. And the first we are going to look at is the Nigerian legislation. That is the first source of Nigerian law that we are going to look at. And the first question we need to ask is, what is a legislation? A legislation can simply mean law. It can mean law enacted by a legislature, and they are usually in a written form. Do we have any Senate member here, or any member from the House of Representatives? Do we have them here? even if they are probably taking this course, they may not want to be in this large hall with you because they feel they are not safe. Okay, so a legislation can mean laws enacted by the legislature, and the legislature or the legislative arm of government is the arm of government that is responsible for what? For law making. So when the legislature exercises a power vested in it by virtue of the provision of the Constitution of the Federal Republic of Nigeria, what they come out with are laws. Of course, these laws sometimes will have different names, but at this stage it does not matter. What matters is the fact that they are laws that can be applied to the Nigerian people or the Nigerian states. So, laws enacted by the House of Assembly, we need to meet and pass through prescribed processes. Same thing with the laws made by the National Assembly that makes law for the Federation. Laws are not just made because they feel like making laws. Oftentimes when laws are made, it is made in pursuant of a particular need in the society. So when the laws are to be made, they are to be made in accordance with the way the law itself has provided. And that's why we have the law go through various stages before the president will either give assent, and when the president refuses to give assent, the bill returns back to the House, where they vote to veto the president's power, and then such laws becomes the law for the federation. So what we're saying in essence is that the Nigerian legislation, which amounts to law in simple terms, go through required procedural steps, both at the national level and at the state level. Because just the way we have the national body that makes law for the federation, in terms of the National Assembly, we also have the state houses of assembly in all the states of the federation. And I know even though there are people who do not know what they do there are people who will probably be aspiring to become honorable members in those houses. But what we are saying here is that if you eventually get there, number one, don't forget some of us that were your friends in this class. Number two, don't forget that the primary role of a legislator is to facilitate the process of lawmaking for the states. All right. So, legislation is a powerful and exigent source of Nigerian law. Okay? Legislation, that is Nigerian legislation, is a powerful and exigent source of Nigerian law because it is the deliberate exercise of the power of a nation or a state to make law for itself. Because it is the deliberate exercise of the power of a state to make laws for itself. Now, we need to say that we borrowed or we took some laws from our colonial masters. That doesn't make those laws to be superior to the ones we have. Do you understand what I'm saying? Our own law is superior. And those laws that we borrowed one way or the other has been legislated or transformed or accepted into our system before they can be operating. So when a law is to be taken into Nigerian state, it will pass through the National Assembly, and the National Assembly will have to enact it into a law before it can be operational. That is to say that without the Nigerian legislation, no law, no foreign law or other laws can be effective within the Nigerian states. Are you following me? Alright. So therefore, we submit that Nigerian legislation is a powerful and exigent source of Nigerian law because it deals with the deliberate exercise of the law-making powers of the states. And like I said earlier, the Nigerian legislation, that is Nigerian law, is seen as the most important legal instrument that we have as a people, because it is the law originating from our efforts. There is no way that an adopted child can really take the place of the biological child, even though in the face of it you have formalized it. Even if the man of the house will accept that this is my son, the woman in the house will never see that one as superior to her own children. Women are not lying, because when I said there's no way that an adopted child will be superior to the biological child, some of you are looking at it as if I'm not making a sense. So what I'm trying to establish is that those laws that we brought into our system, they become operational only when our own law validates them. If the National Assembly does not enact them into our laws, our body of laws, they cannot be operational. And of course, that is because the Nigerian state is a sovereign state that cannot be burdened by the laws of other states, because we are independent, and until otherwise, our laws will remain supreme. So therefore, what we are saying is that our laws carries tremendous effects on all other sources of law that is operational in the Nigerian states. So that is what Nigerian legislation as a source of law means when under this topic. So simply put, Nigerian legislation means the laws enacted by Nigeria for the Nigerian states. What are the types of Nigerian legislation? Number one, ordinances. 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 What? I should spell it. I said types of Nigerian legislation include, number one, ordinances. Ordinances is spelled ORDINANCES. Ordinances are laws or statutes which were enacted by the Legislative Council, which then made law for Nigeria. Ordinances are statutes enacted by the Legislative Council, which made law for Nigeria as at that time until 1954. I repeat that ordinances are statutes which were enacted by the Legislative Council, which then legislated for the whole of Nigeria until 1954. So prior to 1954, there was a Legislative Council. The Legislative Council was the body that makes law for Nigeria. So all the laws made by that Legislative Council until 1954 are what we call what? Ordinances. The second one is Act, ACTS, not the Act of the Apostles, but just Acts. If I find out now, I'm sure some people will have written the Act of the Apostles. What does Act mean? Acts are laws made by the federal legislature. Acts are what? Are laws made by the federal legislature. Any law made by the federal legislature, which include the National Assembly and the House of Reps, are called what? Acts, ACTS. The third type of Nigerian legislation is laws, LAWS. That is number 3. The first one is what? Ordinances, followed by acts, and the third is laws. Laws are state enacted laws. That is, laws made by states during a civilian regime. Okay? So any law made by the Lagos State House of Assembly is referred to as law, because we are we in military regime, or some government of you are arguing that we are in military regime because you are not allowed to exercise some rights. But as for the purpose of this class, we are in civilian regime. So any law made by the federal body during this civilian regime is known as acts, while the one made by the state houses of assembly is referred to as what? As laws. So another type of legislation in Nigeria is what we call decree. Decree. DECREE and S. Decrees. DECREES. Hope you got that. So decrees are laws made by the central lawmaking body under a military system of government. Decrees are laws made by the central lawmaking body under a military system of government. And the fifth type of Nigerian legislation is known as edicts. EDICTS. Is that your name? I didn't say edito. Edicts. Yes, EDICTS. So edicts are laws made by the law-making body of a state under a military system of government. Edicts are laws made by a state under a military regime. Under the civilian regime is known as what? As laws. While under the military regime is known as what? As edicts. While at the federal level during civilian regime is known as what? As acts. Then military regime is known as what? As decrees. So it's very easy to know. If you are really in this class, you'll be able to follow. We also have another example as bylaws. Bylaws. B-Y-E-L-A-W-S. Bylaws are laws made by local government council in areas within their competence. Bylaws are laws enacted by local government councils in areas within their competence. In area within their competence. Now, what do we mean by that? In the Constitution, we have what we call exclusive list. We have concurrent list and the residual list. What? Residual. I want to explain bylaws to you. You want me to spell bylaws? When you want to write bye-bye, that's it. So I've mentioned three types of lists: exclusive list, concurrent list, and what? Residual list. Now there are matters that only the federation can make laws on. Issues of defense. Those are exclusively for the National Assembly to make law. For example, whether or not Nigeria's defense system should change or should be altered is within the powers of the National Assembly to do. And those items that the National Assembly can make law about are the items that are found under exclusive list. But for the concurrent list, the federal government and the state government can make laws on them. Examples are issues of education. Because we have federal universities, we also have what? State universities. So issues of health can be legislated upon by both state and federal because there are issues that concern both arms. Then the residual list is the one that are not contained within those two, that falls within what the states can legislate on, and consequently the local areas. So when we talk about bylaws, bylaws are the laws made by the local governments in the areas that falls within their power. For example, the market women that are in this class, or the business women, let me use that word. Some people will come to your shop and give you tickets. Abi madam, that ticket, if we use our local parlance, we say they're not born you when you don't pay them. Abi, because they will not allow you to sell, and there is nothing you will do. You will have to do what? You have to pay. Why is it so? It's because by virtue of our laws, the local government is empowered to collect such rates. So they also make law. That's why sometimes you see they do minor repairs of roads, they do neighborhood watch, they manage your streets, they determine whether they can give you approval for a particular street to be named after you and all of that. So all the laws that will be made by the local government is what is referred to as what? As bylaws. So what this means is that the Constitution of the Federal Republic of Nigeria distributes powers to the various constituents of the Nigerian states, which is the federal government, the state, and what? And the local governments. Now, how are these laws made? That brings us to the topic, the legislative process. Okay? The what? The legislative process. Now, let me ask this question. What is the rationale for lawmaking in a particular country? Yes. To regulate the activities of citizens, very correct, yes. To maintain law and order, yes. Yes. You don't know reasons why laws are made? For stability, yes. Sir, in resolving dispute, yes. What? To curb excesses, yes. Punishment of lawbreakers. Are you a lawmaker? Yes. So those points that we have mentioned are the reasons, some of the reasons why we make laws. Now, I will let you know from my own end the rationale for lawmaking process. One of it is the ever-evolving nature of the modern society. One of the rationale for lawmaking is the ever-evolving nature of the modern states. Do you know that the world is changing every now and then? Of the modern states. Yes, modern states. Not until 2019-2020, some of you did not know that there was an app called Zoom, right? And not until recently, so many of us too were not aware of AI, artificial intelligence boxes and all of that. As at the year 2007, for those that were already born then, you don't know that there is anything called social media, isn't it? But now, there is social media. Through social media now, citizens of a country can mobilize for a lot of things. And that's why at a time, the government wanted to stop this idea of social media. So what that one has caused is that it made the Nigerian state to make laws regulating social media. In the days, sir, excuse me, sir, when you were in your younger days, I'm sure there's nothing like, even internet, some of you don't know what internet is. But now we have cyber law that are law that deal with cyber issues. So as the society changes, the need for law will continue to what? To change. The time will come now that these phones that you are carrying will become, say, grandma, you mean this is the type of phone you were using in your time? The one that you are dying to buy now, is it iPhone Pro Max or iPhone Max or they will ask you, sir, in your days when you were a little boy, are you with me, sir? I will be disturbing you as you are disturbing my class. In your days when you were little, I'm sure there's nothing like phone. No phone. A time came that the landline came and you have to go and queue in somebody's house. Even in that. Yes, to receive call. But now there are people in this class with 5 phones. There are people who are engaged as PAs to help to carry phone for some people. So a time will come that what you are carrying and say this is the latest iPhone. There was a time BlackBerry was it. If you want to ask anybody for any favor, you will ask him for PIN. Some of you don't even know what PIN is now. So because the society continue to change, there will be need for laws to be made. Number 2 is the consistent advances in science and technology. That is the number 2 reason for law making. The first one is the ever evolving nature of a modern society, while the second rationale for law making or for legislation is the consistent advances in science and technology. You see, as I'm talking to you now, there are some people in this class with apps that is picking what I'm saying and translating it to a written word. I hope you know that. A time will come that there will be no need for secretaries for any meeting, because now there are apps that captures everything you say word for word, and when you are done, it will ask you, how do you want me to format the minutes of this meeting? Number 3, constant changes in government policy. Constant changes in government policy is another rationale for law making or for legislation. Number 4, like my brother here said, to maintain law and order. And number 4 is to maintain law and order. Number 5 is the regulation of different aspects of a modern life. Okay? So now, let's go. Number 5, I said regulation of different aspects of modern life. Regulation of different aspects of modern life. One of that is becoming rampant now is that if you are a woman, you do not want to give birth, you can engage another woman to give birth for you. Surrogacy, abi? In a modern life, Sir, I will still come to you. In your days when you were, have you ever heard of something like that before? So, what? Omali. Okay. They said that's what they will call the child. But there are people in this world now who did not give birth to their children by themselves. To God the children through surrogacy. And they are deemed as, in fact, by the time the child is big, he can sue the father if he decides to say anything that he doesn't like about how he came into existence. Alright, so let's go to the legislative process. Like I said, every law is still under the same thing. If you have written legislative process before and you now wrote rationale for law making, you can still continue from there, still on the legislative process. That is how laws are made. So, one thing we need to state here is that law begins by what we call legislative proposal. Not number 6. Law begins by what is called legislative proposal. I'm talking now about the legislative process itself. That is the various steps of lawmaking. So it begins by legislative process. And what do we mean by legislative process? When situations are happening in the society, people will begin to monitor it. Right? We begin to observe. Then a time will come that we can put up a paper to say this is becoming a menace in the society, so let's make law on them. Do you follow now? So a group of people can come together and form what they call memorandum and say it is becoming increasingly rampant and dangerous for our society that children that are in primary 5 are already carrying phone to school. So why don't you come up with a law that will forbid them, at least for that tender age, because they cannot manage it. Even adults, there are people in this class now who are browsing, they are here, they can only hear what I'm saying, but they are rooted in their phones. So a group can come together and say, oh, we discover that the level of education is, or level of interest in education is going down, because our little ones are embracing a lot of things that is taking their interest away from academic work. Why the noise, please? Are you tired? So that proposal or memorandum can now be submitted to what we call the Law Reform Commission. And when it is taken there, they can now help the group to restructure it into what can be presented as something that can eventually become a law. So that is what we mean by legislative process, proposal, which is usually the first step in the law-making process. So once that is done, the actual process now begins from the floor of the law making. Of the houses of assembly or the National Assembly. It will be at the houses of assembly where it is a law that pertains to the states. If it is a law that pertains to the federal, where will it go to? To the National Assembly. So once it gets to that point, it will be converted into what is called a bill. B-I-L-L. And then the first part of that procedure is the introduction of the bill to the honorable members. Okay? It will be introduced to them that this is a bill coming from XYZ on the issues of the need to focus more on education for the little children. And then it will go through what we call first reading. That first reading is simply to draw the attention of the honorable members. Even though some of the honorable members may be sleeping while they are reading those things, but some will be actively alive to hear what they are saying. Madam, don't you sleep? You sleep now, so they can sleep too. But I'm just saying that while the law is being read for the first time, they can be sleeping. But it doesn't stop their salary. Yes, and some, it doesn't stop their re-election. Okay, so it will be read at first reading. And that first reading is to make the legislators, the honorable members, to get acquainted with the bill or the proposed thing that is to become law. So at that stage there is no debate at all. Why? Because it's just to introduce it to them. Then after that, the bill is moved and read for the second time. When it's read for the second time, it now provides room for debates. Why the debates? For example, if part of the bill, the proposal, is that it will become a criminal offense for any mother who releases her phone to her children at the age of 5. Are you following my point now? I think the mothers will judge the children more with their phones so that they will not cry, take and play. And then some of them get engrossed. At that tender age, they even know more than you who got the phone. So the debate may be that why should we criminalize a mother or the act of giving a child phone? Argument may ensue to say that, don't you know that the world is going to a state now where book will no longer be needed? So they should be allowed to get used to telephone at that tender age. So there will either be debate for and against at that stage. And so, but at that stage, other people may also suggest that instead of completely banning the use of phone at that stage, why don't we include that this is the kind of phone that is regulated for this level of students? You know, those are meaningful contributions that are likely to strengthen the what? The law. For example, there was a law that was to be passed at one of the whether Delta State of Assembly that is to criminalize actions that when you allow your children to be selling during school hours. And I can't remember where I saw it, but there was an argument that, do you think it's everybody that can survive if they don't send their children to go and sell? So why do you want to punish somebody who is already in poverty? So these are issues that come up during all of those stages. So they debate the general principle of the bill, they ask questions, and then they can add to it, they can remove part of it where they believe that it's not in the best interest of the country. Then the next stage is that the bill, you know what the bill is now? The proposed law will be sent to a committee. a standing committee of the House which have oversight function on that aspect. This aspect, which aspect are we talking about? This example I gave you, which aspects? No, the bill itself. You have tried, but there is a particular area of our life that it covers. Anybody that can give me that answer and get 5,000, go and take ice cream. See the way you came alive. Maybe as big as you are still clamoring for 5,000. Don't make noise in my class. Big people like this asking for 5,000. The area we are talking about is education. Is it not education? So at that stage, the bill is referred to the Standing Committee on Education. It's a smaller group that is given the power to review what they are saying. So the committee is expected to further debate, look at it, make suggestions, and also provide further details for the bill. And at that stage, they can also make alterations. They can amend the laws, the bill at that stage. And when they are done with their review, they send it back to the House for further deliberation, and which is usually for further reading. Okay? And when the bill is being read, which probably like the third and final stage, then the legislature will now take a vote as to whether or not to accept it to become law or not. But the majority will always have their way. But for a bill to be passed by the National Assembly, it must be sent to the other house. You know, we have two houses. First is what? The Senate, and what? So if the bill is originating from Senate, before they can pass it, it has to go to what? House of Rep, for them to also put their inputs. And if they both agree, then the bill may be deemed to become a law temporarily. Temporarily, use the word law because it has not become law yet until the president signs it. If you recall, there was a time during General Buhari's time, they sent a lot of bills to the president and he did not give his assent. The president may be right for many reasons. If he feels that at that stage, the nation does not need something like that. But when it is sent to the president and the president signs it, it automatically becomes what? Law. But where the president refuses to sign, meaning that he withholds his assets, the bill is then brought back to the National Assembly and a vote is put in place. And if the 2/3, that is 2/3 of the total members of the House, says it should become law, automatically it will become law as against what the president wants. Okay? Ma'am? Yes, they can. But they must first of all send it to the president, and it will be within a period of 30 days or thereabouts. The president is he has a choice to either assent to it or not. Take for example, you are making a law to say that anybody above 70 years should not run for the presidency of this country. How old is President Tinubu? You don't know. The one we know. Yes. No. He has. No. The reason for all of that is well written in our law that only the legislature cannot make law and it will stand without the president giving assent. Let's say, for example, President Tinubu is 65 years because this man said we don't even know. Now you are now sending a bill to him that he should endorse that anybody who is above 65 years should not be allowed to run for president of this country. Because whether you like it or not, President Bola Ahmed Tinubu wants to come back. Oh, look at you. Better Bakamu. So, if you send that kind of a bill to the president, do you think he will sign it? He is not likely to sign it because they have said 4 plus 4 is 8. Whatever that one means, we get there together. Yes. If he doesn't sign, that's what we have explained. It comes back to the house and they will put it to votes. Once they put it to votes and 2/3 of the entire people says yes, so be it. It becomes law. Yes. I can't remember specifically, but the president, but you know the kind of democracy we run here is I don't know how to say it. The president and the legislature, they are like one. So before anything happens on the floor of the house, the president is even aware. Some of you are in student government now. You say senator, this. The senator is sitting with you, the president, and then say, oh boy, when you go to that place, this is what you want, and so be it. Yes.
In the scenario where the president
yes
affect the signature
yes
on the bill, and he sends it back to the house gets it back.
Yes.
Is it right for the president to rally around the senator and say, see, I don't want you guys to wait on it, or even send anything?
If the president is refusing assent, usually he will give his reasons. But it is only when the reasons are not sufficient and the legislators feel that the nation needs that law that they will go ahead to enact it into law. All right. Yes, please.
So why is that? If the president is found like, if the president has invested money,
yes.
Why is he hard to the president or he's going to move it?
If the president has done what?
Found like in the aspect of theft.
Yes.
Like investment of money.
Yes.
Why is he hard? You know, the Senate, why the Senate have the power to move the president?
Yes.
Why is it hard for the Senate to move it?
It's not hard. It's only when they don't want to do it.
But the president is corrupt.
Which of the president? Your class president? Which one?
When we hear this thing, it depends what the people spoke.
Hello, class.
Please, reality on ground.
Yes.
I watched a clip.
Yes.
I watched a clip on the floor of the Senate of Ghana.
Yeah.
Where the president presented his bill to the Senate of Ghana. The way they dealt with that bill, they sent his chief of staff to defend the bill. It was a budget, rather, for him. The way they dealt with it, the man got muted at the point. He couldn't say a word because they tackled him figure by figure. But if this same thing comes to the floor of Nigerian Senate,
my brother,
the reverse
it will not come.
Why is it like that?
It will not even come. Don't worry yourself. Before anything comes, they already have their own. Yes, yes, let's hear you. Where come now? Yeah, I understand the pain of this man. As much as he desire for a good country, we are not ready. When it is time for election now, some of you that we are here now, you will collect 5,000 and you will still vote for them.
I just wanted to ask, can the president veto powers like overshadow the legislation?
No, it is the legislator that can veto, that can override his decision not to give assent if they feel that the law is needed. Do you understand? If the president, yes, does have final say upon giving it to him. Giving it to him, he can either give assent or no. That's the final say on that. But where he refuses, it comes back to the house, and the house now decide whether they want the law or not. If they want the law, they take a vote. 2/3 of the total house. If they vote in favor, it becomes law. That's the procedure. Because if it is not done like that, in a democratic setting, if the president does not want it, all he will do, he will not sign.
Sir, the fact that the judiciary, the legislators and the presidency are not at war,
Yes,
doesn't mean that the legislators are not doing their job, and it doesn't mean that they are cooperating. On several occasions, we have to consider the interest, the overriding public interest of the society,
yes,
than our personal interest. What Nigerians want to see,
yes,
in quotes, what Nigerians like to see, in quotes, a performing senator is a senator that makes noise, whether it's neighbor noise or neighbor noise. For instance, there's a noise that is going on right now. The issue of, I don't want to go into it, I don't want to, but I'll touch this. The issue of Senator Natasha. Natasha is not in the Senate to go and fight for gender equality. Natasha is in the Senate for Kogi, for her co-guide. Kogi is suffering, Natasha is suffering another thing. So this put between the legislative and the executive arm of government doesn't actually, sometimes they have to work together.
Oh, all right, thank you very much. Hello, class. I think our time is already fast spent. I'm supposed to close this class now. So, like I said, the time is not enough for us to talk to deal with this. Yes, you have a question. Yes.
Both the judiciary and also president election, do you think our votes are
My sister, ask your neighbor. Okay, that's okay. Okay, that's okay. Let me just. No. I will not be able to take more questions. Let me just be able to treat two sources, then we can call it again here. Okay? Because if I continue like this, we'll probably not live there. I understand the desire for a better country. Right? If we are in a same country, some of you will not be here. Some of you now, you are working and you are doing this. Things are choking you and you are still moving on. So a lot of things are not right. So I understand. I could see but make we dey manage. The day we are ready to be free, we will be free. But for now, we are not ready. The second one is receive English law. Please, I will try as much as possible to be fast because my time is already up here. I do not want to eat into other people's time. So received English law refers to the body of English laws that were formally introduced into Nigeria during the British colonial rule. That's what we mean by the received English law. Okay, and this includes the following. Number one, the common law. Number two, doctrines of equity. Number three, statutes of general application enforced in England on or before 1st January 1900. So I'll repeat again. The first one is common law. Number two is doctrines of equity. Number three is the statutes of general application enforced in England on or before the 1st of January 1900. And why did we bring out these laws into our system? The laws were brought into our system to fill the gaps that exist in our legal system. Okay? That's why we brought in those received English laws. Yes, to fill the gaps. We are talking about common law in this class. So common law is not a new thing to you. So simply put, the English common law refers to the unwritten legal principles developed by judges through the decisions of courts. And that's when we were explaining that it is rigid, it's very harsh, and so on and so forth. While the doctrine of equity, on the other hand, refers to supplementary common law by introducing fairness. Like I said, common law are the unwritten legal principles developed by judges through decisions of courts. That's what we mean by common law. The doctrine of equity, I repeat again, supplement common law by introducing fairness. In this class also we have talked about equity extensively. Then the statute of general application, which is the third example of the received English law that we have mentioned, means acts of British Parliament that were in force in England as at 1900. Okay? So all of these laws were British laws that came into the Nigerian states for the purposes of filling the gaps in our laws. Okay? And the Nigerian states apply these laws in the areas that we don't have our own legislation, where our own legislation does not provide for those things. Okay? And that is one of the ways the received English law has been a blessing to us. So, but these laws are only applicable, like I said, on the areas where we don't have laws as a people. But of course, it has been like that, and we have also grown by also developing similar laws to cover all of those areas. And that's why in the case of LAW-NTRO and Abake, the court ruled that the received English law will only apply to the areas of our lives where we don't have our own laws. Okay? And again, that it will apply to the extent that the local laws, local situations permit them. meaning that our own local laws will always be superior because they were made having us in mind, unlike those that were made that we brought into our system. So that is the received English law for us as a source of Nigerian law. But we must say that the received English law played a foundational role in the Nigerian legal system. Because when we started, these were the laws that helped us until we were able to what? To make laws to cover majority of our aspect, the aspects of our lives. Okay? So, we have succeeded in looking at two out of the legislation, out of the sources of Nigerian law that we have mentioned. So when we have opportunity to meet next time, we will start with case law, okay? And then we trickle down. But like I said, I don't know when your next class will be. What?